So as we design this program, we often try to start, as we did today, with a couple of survey issues in which you can see a survey of sort of what's happening in the litigation space, see a survey of what's happening in the legislative and rules-based space that may affect you, and then we go and do some deep dives into specific topics. Before we go to specific subject matter topics, though, this year we thought one of the great things that we might do is have a plaintiff side and perspective side, and defense side perspective of what happens behind the scenes, maybe before and while you're hearing a case. What is exactly happening to prepare the case, what's happening to develop the case and to develop the defense. And so we're delighted to pull a panel together to give you that, that view of the cases. And to lead us in that discussion is going to be Judge Andrew King. Judge King is a judge on the Court of Appeals of Ohio, 5th District. He has held a number of different positions inside the state, including in the Secretary of State's office, as well as in the Attorney General's office. And he's also been both a prosecuting attorney as well as a public defender in the state of Ohio. Judge King received his BA degree from the Ohio State University and his JD summa cum laude from Capital University. And as with all of our moderators and panelists, please do consult the QR code to see their full extensive bio of experience and expertise. With that, I'm going to turn it over to Judge King to lead us through our discussion of the process of developing a case, views from the plaintiffs and defense bar.
Well, thank you. I hope everyone's enjoying this. I'm enjoying the topic, so hopefully this topic will carry us through lunch, because as we all know, before lunch, that's when it starts dragging, right? So, I'll try to make it lively. I've told the panelists I'll try to get a fight going. If we can get being wielded, I'll do my best. I can't make any promises. So I think this will be a great panel with some great panelists. As was mentioned, I'm going to just do some brief intros and then turn it over. Everyone will get about 15 minutes. Give an opportunity to respond, and please come to the microphone if you have any questions. And because there'll be short bios, please use the QR code to get a full understanding of each of the panelists' background. So I'll start with James Stengel to my right here. He represents clients in large, complex, multi-party class action litigation, particularly actions involving chemical, building products, and medical devices. He's considered a leading lawyer in his field by publications such as Chambers USA and Benchmark Litigation. He's known to be able to handle a wide range of mass torts and class actions, particularly in the toxic torts field. Before joining his current firm of Orrick, Jim was a partner at Donovan, Leisure, Newton, and Irvine, LLP. So then moving on to Michael Warshauer. He's has a successful track record of handling a number of complex personal injury cases that have had jury verdicts from $1 million plus to more than $10 million. There's 3 decades in the legal field. Michael's well known for being able to handle complex and difficult cases. Among that, he's considered a preeminent expert in railroad safety laws and has worked with bringing railroad safety to the benefit of the workers through his practice. He's recognized as a Georgia super lawyer for 19 consecutive years and has got a 10.0 rating by Aviva and has got an AV rating preeminent rating from Martindale-Hubbell. He's also a board certified trial advocate in Georgia and one of the few that has that certificate and limits their practice to plaintiffs with catastrophic injuries. And finally, Aviva Wein is the Associate General Counsel at Johnson & Johnson. She has a really long title, I promise you. So she is tasked with developing processes aimed towards anticipating and mitigating litigation risks of the company's products throughout their life cycle. She's responsible for the products liability litigation of several of the company's product lines, such as medical devices and pharmaceutical products. She's been at Johnson & Johnson since 2012, and prior to that, worked for a law firm in New York City. She's a graduate of Brooklyn College and received her law degree from Fordham University, and also clerked for a judge. So it was Judge Michael Moore of the United States District Court for the Southern District of Florida. So there are your panelists, and I'll turn it over to James, or do you prefer Jim?
I prefer Jim, that's
Jim.
fine. First, a disclaimer. My views today are going to be mine alone, not of any firm or any client. That may become more acute as we go on, particularly if we're, I guess, another Ohioan, Jerry Springer, started the chair
right.
flinging.
There
So maybe we can avoid that. I am a defense lawyer, and I don't want that to sound like the first part of a 12-step program, but I do want you to know that I have certain biases when it comes to this. And I want to talk today about two different things. One is so you have a better understanding of what we do as defense lawyers when confronted with a case in the first instance, what values we're trying to achieve, what we're trying to do. And then talk a little bit about how the changing environment of the last 5 to 10 years has really impacted how we defend cases. Because it's been a lot of developments in terms of how jurors react to our cases, what public perceptions are, and I think in some ways it's impacted very substantially how companies defend these cases. First, in terms of how we solve a problem for a client. And that's really the business we're in, because if we say we're litigators, we're selling a service no rational defendant would ever want to buy. We are there to solve a problem. And from your perspective, you're confronted with a case. Plaintiffs, defendants, it looks relatively simple. What we're looking at from a client perspective is a whole host of other issues. Do we have efficient use of insurance assets? What reputational risks are attached to this litigation? Is there a regulatory overlay that could come into play because of this? What are we going to do in terms of remediation? Do we have to take the product off the market? Do we have to change manufacturing processes? There's a whole complex of issues. How do we maintain privilege as to our communications? Do we have the expertise in hand right now in-house? Do we have to go find it? All those things have to be answered. In today's environment, one of the things that's changed is the speed with which, and I'm going to talk from a fairly mass tort-centric perspective, and I apologize for that. I think this has applications outside that, but I think most of the mass that we worry about in the litigation area comes to sort of fruition in the tort space. But we have all these values to deal with, and how does that matter to you as a trial judge? Because you could shrug and say, that's your problem, not mine. But I think a judge has to take a somewhat broader view, particularly when cases are becoming mass cases. And this population is a set of state court judges. As you know, there's a huge amount of activity in the federal MDLs in the mass tort space. Not all cases should be in federal court, can be in federal courts. They're going to fall to you. There, in varying states, you have internal consolidation processes. If you're in California, for example, you have a fairly advanced process to consolidate your sort of intrastate MDL. Texas has something as well. Think about whether you should be thinking about that. The party will bring that to your attention, but it's something you ought to be having in mind. The other part of this is coordination with the federal courts. I've seen, particularly some special masters have been very effective. The late Francis McGovern was really good at this in trying to bring together what the state courts were doing and what the federal courts were doing. And it helped the litigators on both sides of that equation. In terms of what's changed, why is the world more difficult today? And some of this is going to be subject to connection up objection, because I'm going to touch on some things you're going to hear specific panels about. Litigation funding is obviously a hot issue. Scientific evidence, I think you're going to hear this afternoon. But all these things can intersect in the mass space, and they're things we have to sort of come to grips with as we move forward. Now, what's changing? First of all, post-pandemic, there have been serious changes in public attitudes and through that jury attitudes towards defendants in cases. My firm has done some survey work, and I can't say this is definitive science, but I think it's indicative, it's useful to look at. We went out with a jury consultant we work with and talked to about 1,300 potential jurors and sort of tried to assess through polling what's changed. And the things that we heard were not going to be surprising to you is post-pandemic, people are very suspicious of quote-unquote experts. They have a very dim view of corporations. They are interested in sort of justice, and justice in their mind sometimes involves substantial transfers of cash. They are also less sort of rule following. And one of the things that I think has come up, and we've seen this from a political perspective, is people tend to be harder to move off their initial impressions. And for us, that may mean, unfortunately, somebody in voir dire comes to a conclusion about a particular case. And they may be very hard to move. And all these attitudes and approaches are hardening. And again, what's it mean to you? And here, I think you have to be sensitive, and I'm not suggesting, and you'll hear from a plaintiff's lawyer, I think we all have an interest in the creating the fairest set of outcomes we can. And the things that interfere with that are the fact that there's a disconnect in the litigation system between what the legal needs are and science. A lot of mass torts involve either non-existent science or immature science. And the courts are forced to deal with the fact, through evidentiary standards, of the fact that there is this disconnect. Now, does that mean you dismiss all the cases? That would certainly be my dream. But it may be dismissals pending, tolling. You have a registry. You put cases off to the side because there's no evidentiary basis today. Again, I'll repeat the disclaimer that I'm speaking for me and nobody else. The other thing you may need to think about is whether you need your own scientific help. I've worked on cases where we've had 706 panels, which have been critical to the resolution of those cases. And again, your jurisdiction may have different rules on how you go about doing that, but having an independent science advisor to the court, not to the parties, can be very useful. Judges have done creative things to try and sort of parse the science. In the PFAS MDL, Judge Gergel, for example, has had a series of science days. He's also challenged both sides to come in with their evidence as to what disease processes could be potentially associated with this product, and he's limited the population from well over 200 asserted disease processes to 8 at this point. He's not dismissing with prejudice all those other cases. They're going into essentially a holding pattern. But that's something you need to talk about. The pressure that builds in these cases becomes because of the mass element. That becomes a leverage point against defendants by itself, and that really shouldn't be the case. And that's where you get a pernicious intersection of, and again, you're going to hear about this in greater detail, litigation funding, in my view, has facilitated the generation, or the creation of a whole industry of claims generation. If you went back 20 years ago, we used to joke that mass torts have a variety of causes, but mass tort litigation is caused by Connie Chung. Now that dates me, but she did very spectacular exposés on breast implants and diet drugs. Now we have a whole industry that looks for any potential claim, and once there's a potential claim identified, they can generate an unimaginable volume of claims, which puts a pressure on us here and you to figure out how you deal with the fact that there's this sort of one-tailed distribution of claims in the mass tort space. There are going to be, in most cases, claimants, and I'll use the mesothelioma case as an example. Those people are indisputably sick. The odds are pretty good they're sick because of asbestos exposure, but that may have nothing to do with those that have been sued and the claims have been asserted against. And sort of figuring out how you're going to filter, is there general causation, is there specific causation, and is there a product ID causation element that could sustain any kind of scrutiny, is all part of the task that falls to all of us. And in the MDL context, one of the popular devices has been a lone pine order, plaintiff fact sheets, a threshold determination that you have to show that you have some level of impairment or disease that could potentially be related to the products at issue. That's sort of progress in small steps. We are limited as we go forward. The procedural devices available to us have changed over time. Going back a fair distance, we used to think we could use class actions because they had preclusive effect. We could sort of resolve litigation that way. The Supreme Court in Ortiz and AmChem sort of said, no, not consistent with due process. We've then moved to the world of the MDL, which of course only cabins those cases that are amenable to federal jurisdiction. And there are lots of criticisms and complaints about the MDL process because it's not transparent. There have been some survey work published in the last year or so, I think by Professor Sharkey from Georgia, which talked about how unhappy plaintiffs are in the MDL context. They don't feel like they have any influence over the litigations going. They're not given communication. They don't have transparency. So there's a lot of dissatisfaction there. And then you move to, and we had the questions about the bankruptcy process. Obviously, asbestos bankruptcies have been happening since Manville in the early 80s. The sort of migration to other mass torts has been more variable. Robbins was in fairly soon thereafter. And today there's this whole set of mass tort bankruptcies, the diocese cases, the Boy Scout cases, the gymnastics cases. And bankruptcy, because of limitations of the bankruptcy process and limitations of what claims a bankruptcy court can hear, has some limitations. And I think it's also subject to some level of manipulation in terms of that sort of gives people a reason to go out and generate more and more claims because the view is the bankruptcy is not likely to have a filtering mechanism to figure out which claims are valid. it's going to have to deal with these, and you have distortions that come to voting. The old sort of accommodation of assigning $1 per vote to get around 524G's provisions has a real negative impact when you have claims of uncertain, and I'm being very charitable, value here. So I think right now we're in a world where we all need collectively to find better solutions than the ones we have. The procedural devices we have, and one person's view is I think necessity is going to lead, and this may not be good news for the bankruptcy court or the bar, but I think that's a place where, because it's the only place that we can get both sort of universal jurisdiction over state and federal claims, get to the global piece that defendants want, but I think there's going to have to be an amalgamation of what district courts have done, what trial courts have done in terms of finding ways to screen claims, to sort of change the mechanism of how we value claims and how validity of claims is recognized. And finally, to answer a question put to the last panel about why litigation funding matters, I've mentioned the impact it has on claims generation, and there was a discussion about sort of creating a lottery for claimants. And who owns these claims and who controls them makes a great deal of difference. As I've said, in the MDL context, there's a lot of complaint from the plaintiff side about not being in control of their claims. Litigation funding adds another layer of complexity on top of that because of the Burford-Cisco litigation suggests there's a lot of open dispute about who actually controls these cases. It also distorts the entire system because if you're talking about an individual lawyer with a handful of claimants that he or she knows, those people may have different aspirations and views. They may have different objectives in litigation. If you have a hedge fund that's invested millions of dollars in a mass tort case, they're perfectly happy to sit back and hope they get the nuclear verdicts because that's where their returns come from. And that drives, again, a hydraulic pressure on pushing claims through the system and, again, allows them to maximize the sort of leverage value that comes from the mass of mass tort litigation. And with that, I'll be quiet.
Well, you got a couple more minutes in your opening, so if you don't mind, you mentioned the bankruptcy, and the Purdue case was from the Supreme Court last term. Do you think that has any impact on sort of the paradigm you laid out leading to bankruptcy?
Well, there's somebody on this panel who knows a lot more about that than I do, but I will say, you know, the presumption had been, and there have been a number of bankruptcy cases where they allowed releases for non-debtors, non-consensual releases. And in the Purdue case, that case was all about protecting the Sackler family. And the settlement as structured required a substantial contribution from the Sacklers. We could debate whether it was adequate, but the premise was they would get a release, in effective discharge. Really, it was better than discharge because they got released from some claims that couldn't have been discharged in bankruptcy. But I think a lot of the Boy Scouts, the Catholic Church cases, all the non-asbestos cases, because the Supreme Court went down basically on a statutory interpretation ground saying there's no authority in the bankruptcy code to allow these releases. But what you're going to see, I think, is creative lawyering, and there's a whole nother level of debate about the pejoratively called Texas two-step, whether you can restructure your entity in a way that makes it more amenable to bankruptcy while at the same time providing the relief you want injunctively through non-debtors. So I think we don't know what the long-term impact is going to be. Put to the side the asbestos cases because there's specific authorization for non-party releases under 524G. But that's what the Supreme Court found is there isn't in other contexts. But I think, you know, as somebody who thinks that bankruptcy is ultimately going to be part of the package of solutions here, I'm very concerned. You know, the other option would be Congress could amend the statute and explicitly allow for there to be non-debtor releases. There's kind of another issue about not what non-consensual means or whether full payment cases would support those releases. I've yet to see literally a full payment mass tort bankruptcy. They never come out that way, even if that's the projection at the start. But I think we will collectively be disadvantaged if the bankruptcy option isn't available. And as I sit here today, I can't tell you exactly what the bankruptcy option will look like in 3 or 5 years. But I think it will be a substantial reduction in our ability to efficiently resolve these cases. When I say efficiently, I mean efficiently and fairly resolve the cases. Because right now we can't really use class actions. We can't, you know, there's limitations in the MDL because of jurisdictional limits. And then we see all sorts of other sort of procedural developments like the emergence of all the AG cases, which are sort of an end run around the block on class actions. because they're purporting to sue. And then, as we go forward, somebody in the earlier panel made a comment about sort of legislative dysfunction. We're litigating lots of issues that probably shouldn't be in courts. I mean, why we have, I think at this point, 14 states' court systems dealing with climate change, that's just not, and I know you're going to hear about public nuisance from another panel, but that doesn't seem like to be a rational way to govern ourselves. And I think if you look at a lot of mass torts, there's a similar element of, should this really be opioids is a good example. Arguably not in the solution, but opioids came into being as a problem because of arguable regulatory failure, because nobody in government said, why are you sending millions of doses to some small town in West Virginia? There was an apparatus in place that was supposed to control that, and it didn't. So we are all put in a collective position of having to deal with a problem that others have created with limited tools available. But we do the best we can.
Well, and with that, we can hear the potential counterpoint on some of this.
Well,
So, Michael.
I'm a trial lawyer. I'm a trial lawyer from Atlanta with a law firm of 7 people. I'm past president of the Georgia Trial Lawyers Association, past board member of AAJ. I've been doing this for 41 years, got my bar results 41 years ago in November. I've tried cases to verdict in state courts in at least 9 states that I could think of on the airplane this morning, and in federal courts in probably 12 or 13 states to verdict. I've argued cases at multiple state Court of Appeals and Supreme Courts, as well as multiple United States Court of Appeals. But despite all that, my mass tort experience has been, no, I'm not interested in paying $75 for that lead. No, I will not give you $250 for that lead, but thank you very much for calling. My asbestos experience was I was Ron Motley's law clerk for 2 years in law school of Motley Rice. And having witnessed the wildlife that was, decided that that was not for me. I like representing people I know. I like representing people whose cases I've become a part of. And the resume you read, I have no idea where that came from. I certainly do a lot of FELA work, but that's kind of a business that, through good legal work by the plaintiff's bar, it's a safer place to work. And because it's a safer place to work, there's not as much of it to do. I can go on a locomotive and look at stickers on that locomotive warning people to wear earplugs, and it's because of litigation I did. And I take pride in that. The system works most of the time. I've never done litigation funding, and I've never done cases involving doctors who have giant liens, except my involvement in that is a medical malpractice case against perhaps the largest one in Atlanta, who charges $200,000 for a $20,000 operation. So that's where I am. And I've testified for the Rules Committee at the request of Sue Steinman. But I wanted to share with you 4 thoughts, because it's my belief that the vast majority of gatherings of judges, most of you will never see a mass tort to manage. I suspect that's true. Most of you will never be the designated judge for the MDLs. That's probably true. Most of you never have a class action. But what you will have is product liability cases, serious truck wreck cases, and medical malpractice cases, as well as little car wrecks and little disputes. And so what I wanted to share, because I thought the title might fit these thoughts, was 4 thoughts. We start with Federal Rule of Procedure Rule 1. It encourages courts to manage litigation efficiently and with cost-effective in mind. And so what I want to encourage when we're developing a case, sometimes we'll get a case and I go, wow, these are great damages, because that's always my first question when I screen a case. How bad you're hurt? If you're not hurt bad enough, there may be another lawyer out there, but I'm not the right one. The second question is there any money? Because if there are no money, I don't want to put your family through this if we're going to end up just making you disappointed. And the third question is it anybody's fault? And at that third question, sometimes it's a tough legal question. It may be a question that can be resolved without getting into damages, without getting into expert witnesses. Just was there a legal duty? And I have not been as successful as I have wanted to be to encourage judges to say, hey, let's manage this case with the idea of not putting the plaintiff to $200,000 of full-blown case prep when there's a chance I'm going to lose on this issue that we could have decided with a couple of good briefs. Let's get that done early. And they don't seem to want to be interested in that. And so what I would encourage is early in the process for all courts to say, is there a dispositive or issue precluding legal question that will end the case or shape discovery? If so, let's get it done. And I'll give you an example. We just resolved the case and it did not end well for us, sadly. I think there was intellectual laziness by the courts involved. Had they really read our briefs, we would have had a different result. Be that as it may be.
We always read them, I promise you.
I'm pretty sure not in this case. Be that as it may be, this was a legal question. Could have been resolved early on. Could have been resolved early on. But I had to hire a life care planner. I had to hire 3 experts. I had to do a recreation. Why? Because I had deadlines that I could not get the court to move for me. Now, we lost that case. There was no litigation funding to support that. It's just money we will never see again that we won't be able to use to help somebody else. But if the court had really had a 15-minute call with us, we both knew that question early on. And we could have resolved it. And I think that's something I want to keep. I would hope to encourage people to make that part of their judicial practice. The second thing, and this is something the older I get, the more seriously I take this. Litigation, trials, and appeals are not basketball games. What is he talking about? In basketball games, you're supposed to foul. It's part of the game. 2 minutes left, you're behind by 4, you foul. It's accepted. It's expected. There should be no fouling in the judicial system. There should be no intentional rule violation that's condoned or allowed. But I see it every single day, every day. And I see it more now than I did 35 years ago when I got old enough to appreciate it. Now we have law firms who have one client. 35 years ago, a law firm had a variety of clients. They could say to someone, F you, I'm not doing that. But you look at some of these firms, and we tried a case, it was well more than $10 million, more than $20 million. When it was resolved, and they had done stuff during that trial that was amazing to me. One of my cross-examination questions was, this was a retrial. We got it reversed by the 11th Circuit after some really bad, bizarre evidentiary rulings, but we got it reversed. And so one of the witnesses had been deposed twice, and we had trial testimony. 3 times, he had said 2 + 2 is 4. 3 times. In the second trial, I asked him the question, you'll agree with me, sir, that 2 + 2 is 4. He said, no, sir, it's 5. I said, you recall back 3 years ago, I took your deposition, you were under oath. You said 2 + 2 is 4. Yes, sir. And you recall another time? Yes, sir. And you recall sitting in this same courtroom? Yes, sir. Is it true that the only difference is that this morning you met with those lawyers upstairs? He said, yes, sir. There was no sanction. Nothing happened to anyone, except the jury was very upset by that, which was a good day for us and our plaintiff. But the point is, it shouldn't have happened. We get discovery responses, and the first 2 pages are boilerplate objections. Object to the extent you ask for attorney-client privilege. Object to the extent you ask for obligations beyond the scope of discovery. Object to the extent that the moon is closer to the sun than Mars. It's bizarre. 3 pages of this. How am I supposed to know which of those applies to what question? But courts don't do anything about it. And then when we get to the individual answer, every single question is answered. Object to the extent you've requested attorney-client privilege, object to the extent you've asked for work product, object to the extent it exceeds our obligations under the rules. And I go to a court and say, Judge, I don't know if there's a work product here or not. Help me out. And he goes, oh, get over it. Get over it. That's just the written discovery. Then we go to depositions. And it doesn't really matter what kind of case it is. Some lawyers are going to object to every question. Object to form, object to form, object to form. And you know, when you get to that question that's case dispositive, you're going to get an objective form. I'll give you an example. What color was the light? Objective form. I go, first, I've got him on cross. I can use any form I want. But second, it's a 5-word question. What could possibly be wrong with it? Counsel, I get to make objections anytime I want. The response that I make is, no, you just sent your client a signal. This is the one we're worried about. And then it would be followed with, well, it calls for speculation. Objective form calls for speculation. Objective form calls for speculation. Answer if you know. That is every bit afoul as pushing a guy out of bounds with 2 minutes left. The difference is we shouldn't tolerate it, but y'all do. You just do. Over and over and over you do. Maybe the only place that I can go consistently and not see that objection is in the state courts of South Carolina, where you better, if you make an objection there, you better have your A game on, because they are encouraged to sanction objections that don't make sense, right? Yes. Nobody else does. Then we see lies and briefs. This was at the 7th Circuit Court of Appeals. Judge says, counsel, quote on page 7 of your brief, might not be page 7, but I'm pretty close to this. Your ellipsis left out the entire import of what the court said below. I find that misleading. No, sir, Judge, it's not misleading. That's what he said. You get to the written opinion. Counsel was faced with misstating the record. At oral argument, they doubled down. Was there a sanction? Was there a call out? No. For the United States Court of Appeals, about 15 years ago, I had my oldest daughter there. It's sort of a big deal, you know. And we sit down, and the chief judge says, the presiding judge says, one of you has materially misstated the record. There will be consequences. Like, holy cow, I hope that wasn't me. It wasn't me. And there were no consequences. Because it was the other side, and that's appropriate, apparently. Brings me to topic 3, 702 motions. Some of you may still call these Daubert motions. First off, that makes no sense how a mid-1990s opinion can govern a statute, a rule that's only 2 years old. Makes no sense. It goes the other way. Y'all know that, right? They write the rule, and then the courts interpret it. The rules aren't written to interpret the cases. So don't call it a Daubert motion. I just don't think that's the right thing to do. But what I want to draw to your attention is this. The United States Supreme Court said in General Electric versus Joyner, and that happened to be my case, sadly, they said it's your exclusion of an expert is going to be judged on an abuse of discretion standard, the lowest standard possible. Abuse of discretion. It's a case dispositive issue where both sides have hundreds of hours of time in it, tens of thousands, if not hundreds of thousands of dollars invested in it. And let me put this in the light of another evidentiary ruling that's measured with the same yardstick. We'll go back to the question about the red light. The light was red, wasn't it? Objection leading. Court, can you rephrase the question? Sure. What color is the light? That wasn't a case dispositive question. I didn't spend $100,000 trying to work that up, but I got a second chance. We've got to figure out a way that after you spend all these money on these experts and you find a little flaw, you thought you covered it, your expert thought you covered it, and somebody finds a flaw that you hadn't even thought of, but they really think it's a big deal. There's got to be a way to say, counsel, can you answer that one question before I rule? Now, we have tried bringing motions preemptively to have our experts pre-approved, if you will. You can't make them pre-admitted, but what we say is, Judge, you're the gatekeeper. We have an expert. We would like you to see if they will fit through the gate. And if they do, we're good to go. If not, I still have 3 months on my expert disclosure deadline to fix this. But I'll tell you, it's hard to beat those deadlines because by the time you're getting all the evidence in, you got 2 weeks. You don't have 3 months. Or they won't rule until after the deadline. And that's just because they're busy. But there's got to be a way to do that. And I think the last thing, well, 2 things.
You're running short.
Okay, realistic scheduling orders where you start at the trial and work backwards, not to just have a deadline that ends 18 months before the trial or 2 years before the trial. Let's be realistic. We have real jobs, real other cases. There you go.
Well, thank you. I cut him short, so I'll get an opportunity maybe to respond later or ask a question that prompts that. So Aviva, if you want to take your time now.
Sure, thank you. So thanks for having me here today. As Judge King mentioned, I work for Johnson & Johnson, and I guess I'm part of one of those corporations that people have a very dim view of. And one who's been drinking the Kool-Aid of that corporation for 12 years. I'm proud to do it. It's a company that's 138 years old, was born in New Brunswick, New Jersey, and it's where its headquarters remain today. Over those 138 years, and there's a point to me giving you this history, right? It's evolved from sort of an iconic consumer brand company like Band-Aids, baby shampoo, and yes, baby powder, of which we're very proud, to a pharmaceutical company and a medical device company. And we work in many different therapeutic areas that people might not be aware of, right? We work in oncology, immunology, neuroscience, cardiovascular health, joint replacement, surgery. Probably, if any of you have had surgery in your lives, you've probably had one of our sutures. We're the largest healthcare products company in the world. And why do I tell you this? Not because I'm doing a commercial, right? I think that it's important to put context around some of these litigations, especially when you think about a company. I think there's a tendency to think about corporations as soulless entities, but in fact, they're made up of hundreds, thousands, tens of thousands, and in our case, 120,000 employees. Those are scientists, those are doctors, those are manufacturing professionals. Those are professionals from all walks of life, all areas, all manners. And their goal is singular, right? The goal, at least at our company, is to change health for humanity. And I'm not naive, right? We are a for-profit company. Nobody hides that, right? Those profits are used to drive innovation. And the work that we do is part of the bedrock of the U.S. economy, and it's probably likely to touch some of you at some point in your lives. So when litigation is brought against us that seeks to indict the work that those thousands of people do every day, it's meaningful, right? It's meaningful to us, it's meaningful to all of those people. And it's an indictment of their mission, and it's an indictment of the decades of the commitment that they have to what they're doing every day. And importantly, when you think about litigation, and I am talking, mostly from the standpoint of mass litigation, because that's the largest portfolio of litigation that we have. We have probably more products than any company in the United States, so that is a blessing and a curse. But we pour billions of dollars a year into defending litigation. And that means that the next generation of an oncology product, the next generation of a mental health product isn't coming to market because we're pouring that money into defending litigation. And that therapy that somebody may be waiting for may change the course of their disease state. And so that's why it's important to us. That's why litigation is important to us, not to win because we'd like to win because we're a company and we'd like to save money, but that money is meaningful, and it should be meaningful to everybody in this room because those dollars are used to drive innovation and are used to create the next life-saving therapies. And today, that money is being diverted. And the question that was posed to our panel was, how do you build a case, right? What is the development of a case, the views from the plaintiff's perspective and the defense perspective. So I have up on the screen the view of the defense perspective, or at least the company perspective, from a mass tort perspective. And I think you'll hear a lot of the themes that were touched upon, but I want to walk through this because this is how we look at the business model that's been created around mass tort litigation. This is how we look at the ecosystem that we've become a part of, not because we want to be, but because we've been forced into it. And so if you think about how litigation, particularly mass tort litigation, has evolved over the last 15 years, it really has changed. And it's changed in a number of ways, right? It used to be that a litigation was kicked off by maybe a product recall or an FDA letter in our space, right? But it's sort of not what happens today. What happens today, and a lot of this is tied to third-party litigation funding, is plaintiff lawyers looking out at the landscape of products, looking at, can I find a product that has a large number of customers, a large number of patients, unverifiable use, because as you've heard throughout the last panels here and there, right, that is a big issue. Let me identify that target product. Let me figure out if there's a harm that really actually has myriad causes, and I'm going to decide to bring this litigation and say it was caused by this product. I'm going to then get third-party litigation funding. So I'm not even going to put my own money on the line, and I respect that you put your own money on the line. And I think that it actually probably helps you to think about what case am I going to bring and what case am I not going to bring, right?
That's fair, true.
Yeah.
Totally true.
But when you insert third-party litigation funding into this model, right, and I think the estimate right now is there's something like $15 billion of assets under management, third-party litigation funding in the US alone, that with a return on investment of something like 91 to 93%, it's the best investment class in the United States today. So if any of you are looking to diversify your assets, that's where you should go. That calculus that you do, Michael, right, that flies out the window. Right? It's not, I'm going to look at the merits and do due diligence and decide I'm going to invest my own dollars into 2 out of these 10 cases. It's, I'm going to get funding and throw them all up against the wall. I'm going to take 10 cases and bring them all and see what happens. And why? Because the next thing that happens is a media campaign. And it's not just the advertising that you all see on TV and social media and radio and print, right? It's also in your mainstream media news articles, because the plaintiff's bar has great relationships with media, and they use that as they should, right? But what it does is it perpetuates and pollutes, right, the public perception of the product and the litigation. I think there was a statistic out there that something like 90% of people who see an advertisement about a drug and medical device from a plaintiff's firm assume that there is something wrong with it, right? So that media campaign serves a dual purpose, right? It collects plaintiffs, because call 1-800-SUE your local company. And it pollutes public perception of the product, right? And that's not without risk. So when you're in my world and you're thinking about public health products, right, you're thinking about pharmaceuticals and medical devices, I had a litigation that we managed where plaintiff lawyers had run huge ad campaigns. They spent something like $120 million on ad campaigns against this one product alone over about 5 years. And doctors wrote to us and said, my client saw a lawyer ad on TV, went off the product because they were scared by what was said and died. They stroked because it was an anticoagulant. So there are public health consequences to these ad campaigns. The next thing they do is they think about science, right? Well, let me create some science if there isn't already in the market. So let me hire experts. Let me do some retrospective studies. Let me ignore all of the decades of science that went into the regulatory approval of these products. Let me aggregate huge numbers of claims, right, without any causation analysis. So to the point that was raised earlier about thousands of meritless claims being filed, we know that the estimate is something about anywhere between 20 and 50%, depending on a particular litigation. I can tell you from my experience that is true. Claims fall out. Plaintiffs can't prove that a product was used. They can't use that a product caused they can't prove the product caused the injury, yet they are all put into this black hole. That black hole then becomes an MDL, a multi-district litigation, or sometimes becomes a multi-county litigation in a state, an aggregated litigation in a state. Sometimes you have both, right? You've got an MDL and you've got a consolidated state court action, or you've got state court actions all over the place. And that happens really intentionally, right? And sometimes if the defense gets a good judgment in MDL, the plaintiffs then take their cases to a state court where they think that, for example, they won't get a 702 ruling against them, where the federal court has given it. The other thing that happens, and that's on the bottom there, is that we see that attorneys general delegate their prosecutorial discretion to plaintiff lawyers in the mass tort space. And so they'll hire these plaintiff lawyers to bring adjunct UDAP litigation in the state court system. So you're getting sort of a dual track of litigation. You've got your product liability litigation, you've got your UDAP litigation. You've probably at some point, because of all of the attention, media attention and otherwise, you've probably got a congressional investigation on your hands. You've probably got some letters from DOJ, who even knows, but all of it goes into the building of a successful case from my perspective. And then what happens, right? Michael, you talked about, dispositive motions happening at the very beginning of a litigation. God, I wish that would happen, right? Particularly in an MDL, where you have thousands of cases, and even when you do get to a dispositive motion, it's years down the line, right? It's 4 or 5 years down the line. Whether you're talking about a 702 or you're talking about summary judgment, you're usually about 4 years down the line in a mass tort litigation. And so what does that mean? That means that even if you win as a defendant, you lose, because your product has already been destroyed. And I don't mean that from a profit perspective at all. I mean that from a patient perspective. Because think about yourselves as patients, seeing that product being advertised against on television over and over again. How many of you are going to walk into your doctor's office and say, I'd like to change, right? I mean, it's a natural reaction. I totally understand it. And so public health has been affected. The product has been affected, the reputation of the company has been affected, even if you do get that dispositive motion. And largely dispositive motions are not granted in mass actions. And they're not granted in mass actions for a really understandable reason. You've got thousands, tens of thousands of cases, and quite frankly, judges are reluctant to say, I am going to issue an order that applies to all 10, 20, 30, 40, 50,000 of these individuals in front of me. I'm going to let it go forward and see what happens. Again, an understandable human reaction, but not an understandable reaction from somebody who's supposed to be a gatekeeper and somebody who's supposed to be applying the law. And then what happens, right? So we've avoided dismissal. Either you get a large aberrant verdict because, Jim, to your point, people have a very dim view of corporations. I think that there's been a societal shift that's tremendous post-COVID. I think, there was a little bit of a peak, but then it sort of lost its way. I think that there also is a real sociological study to be done about the population in the US and their belief that they should have access to all information, even if it isn't scientifically valid. And they should be able to make a decision instantaneously, and that their decision is right. And so I think that what we're seeing is huge verdicts because of that, because of the perception that companies are hiding things. And I will tell you from the world of a highly regulated corporation, and again, like Jim, I'm speaking on behalf of myself, not the corporation, obviously, but I do have that experience. We are highly regulated. We don't hide things. We can't hide things. I sit around Thanksgiving tables, just like many of you do, and I have a very outspoken aunt who likes to say things to me like, no, I don't want to use one of your defective products. And I say to her, okay, what makes you say that? Well, one, I saw an ad on TV, so obviously that's true, and I saw it on NPR, so it's for sure true. But you guys own the FDA. I'm like, my God, I wish I owned the FDA. The work that we do to get our products to market, the science that goes behind it is tremendous. But jurors, it's just a fascinating process to watch juries in these very complex science cases. And as a defendant, one of the things that I do, because I don't try cases anymore, right? We're the clients, is I sit there and I sometimes say to our trial lawyers, you're drinking your own Kool-Aid. You think everybody understands what you're saying and you're talking about science this and science that. Nobody understands you, first of all, right? And second of all, nobody cares. So you need to make this more understandable to a regular person who has their emotions are in play and they want to do right for somebody who may be injured, but maybe not by my product. And so that's one of the things. But we're seeing these huge, huge verdicts, right? Verdicts that really demonstrate to me no connection or sort of a lack of connection between reality and a number and a lack of understanding of what's the difference between $1 million, 100 million, and $1 billion? What's the difference, right? Let's just give people money. And I understand that emotional desire. But again, going back to what I said in the first instance, right, there is a consequence to doing things like that, particularly in the healthcare space. So then we've got our large verdicts, we've imposed significant legal costs, and then in the end, particularly in the mass tort space, I think something like 97, even above, more of cases settle. Why? If I think I am so right, and I do, why are these huge settlements happening? Why? Because we're a company, we have stockholders, we need to move past these things, right? We need to do ultimately what's right for our employees, for the scientists who depend on us, for the patients who depend on us. And so sometimes getting these things out of the news, getting doctors not distracted by what's going on in litigation, but focused on the care of patients is more important to us than spending the money. Let's spend the money, let's settle this, let's get this behind, and let's get people back to what they should be doing every day. And I will tell you, in one of my litigations many years ago, it was interesting. It was a litigation in search of theory, right? It really just was. And we spent hundreds of millions of dollars on discovery, because that's the other thing that happens as a huge company. If you think about the mass tort space, the companies are spending hundreds of millions of dollars producing every document under the sun. So regardless of the objections, and I'll wrap up in a minute, Judge, regardless of the objections, I object, attorney-client privilege, et cetera, and I agree. They are overstated in some cases, right? We still produce every document under the sun, and it costs hundreds of millions of dollars, and we have those huge costs. But sometimes, you have those huge costs. Our companies don't understand why it's costing so much. They don't understand why they're diverting money into things like producing documents versus developing the next therapeutic cure. And so the answer is, let's put this behind us. So you extract these huge settlements. And they're huge. Why? They're huge because, particularly in mass torts, there is no vetting. So you've got thousands of cases that don't even belong there. So if you're going to do a global settlement, right, you're going to say, okay, you have 10,000 cases. The other side who's negotiating with us is negotiating on behalf of the 10,000 cases because nobody's actually vetted them. And so the dollar amount that we're going to pay is necessarily going to go up unless we insist on inventory settlements, which is something that we've consistently been pushing, because and some of you in this audience who know me may know that I insist on looking at every single claim in some of our litigations. I want you to show me proof of use. I want you to show me proof of injury, and I want to see it in a medical documentation, not an affidavit, right? So that's how I feel like the development of a plaintiff's case goes. I'm sure there will be some contrary views. I'm happy to hear them.
Well, I thank everyone for their comments thus far. If you have any questions, if you want to start heading up to the microphones, we'll get people queued up. You're a little bit outnumbered on this panel, Michael, so I wanted to sort of turn it back to you, particularly with what Aviva was talking about in the context of toxic torts. Most plaintiffs at least feel like they might be in a David versus Goliath situation. So how do you prepare for these large cases involving sophisticated causation, the need for a lot of experts, the need for a lot of discovery, without resorting to these other mechanisms, class action, the media, things of that nature? Or maybe you can't, but if you want to.
I can speak best to individual claims. And you have to make the judgment call, at least we do. We have to look at the value of the injury, and we have to look at what that's going to cost, and sometimes, and the likelihood of success. I mean, it's a math, if you will. If you had a case that was worth $20 million and there was a 5% chance of recovery, you wouldn't do it. If it was a 50% chance of recovery and you could keep your costs down well below that, it might be more attractive. But at the end of the day, we literally do a present value analysis on how to figure out whether this is a case for us, whether we think it's one for the system. You know, look, you have drunk your Kool-Aid by gallons, and I'm proud of you for doing that.
Thank you.
But there is some truth. But for litigation, what keeps America's corporate entities honest and what ensures that profits are not put above safety? Every corporate decision is this going to cost us if it's bad? And without that potentiality, there could be some really bad decisions.
Well, I'll turn it over to questions, and I just want to remark, as you heard, I kept them to 15 minutes, so that you got a sense of what it's like to be an appellate judge. You live your life 15 minutes at a time, so.
And can I just say, I don't disagree with you that there's a place for litigation against corporations. I absolutely agree with you. I think the world has turned. I think that the marketplace has turned into just a billion-dollar marketplace of litigation against corporations because of the incredible return on investment. But yes, sometimes companies do things wrong, and they should answer for that, and they answer for it in the court of law, and I fully believe that.
Well, I can't speak to the MDL settlements. We've always wanted to know our clients individually, and I've never wanted a client on a grid. Here, there's your money. That's just not the way I think the system would work, personally. But when we talk about increased verdicts overall, the normalization of huge amounts of money from people like Elon Musk, I've got $180 billion. You hear this every single day. So what is $10 million? When over and over and over, you're seeing profits and athlete pay and CEO pay that's just unbelievable. And that normalization comes back to jurors, and they go, you know what? This man's leg is worth as much as a baseball player makes for 3 months of play. And that's not unreasonable to them. So when you're seeing $20 million for something that used to be $3 million, I would submit that if we compare that to what they are seeing every day in the newspaper, every day on the sports channel, these numbers are really quite reasonable.
A couple of things. Is this on?
Yes.
I think
So
so.
a couple of things. Ohio, for example,
You
just
might want to
adopted.
raise it up a little bit.
Ohio just adopted a form of federal rule on discovery that requires so much upfront discovery. So concerning Michael's comments concerning the ability to have those dispositive motions early, Ohio just went the other way, and I think it's consistent with the federal discovery rules, and those rules are mandatory. It's not discretionary, and it requires upfront disclosure of your experts, upfront disclosure of your experts' reports, which increases plaintiffs' costs tremendously and doesn't allow for that early. So I would hope that when people and various people are dealing with discussion of rules within courts, that they consider, wait a minute, maybe it shouldn't be that mandatory. Maybe a case should be allowed. Lawyers say, hey, there's this legal issue, let's deal with that first.
Well, as the federal rules are interpreted in every court I've ever done, when we do our disclosures early on, they do say disclosure experts. But the standard answer is, we don't have them yet, and that's fine. There is generally a deadline in the scheduling order by which they have to be disclosed. So we are seeing that. For example, in a state court, I would send a standard interrogatory, identify your expert with opinions, basis of the opinions. Federal court, I don't have to do that. It's in the disclosures that I'm required to do early on. But the timing is really down the road in litigation, in every case I've ever been involved in anyway. Would you say that's?
Yeah, most federal courts take a reasonable view on the mandatory disclosures. They're a hammer if somebody's recalcitrant. But what this sort of, I think the broader point I was trying to make, maybe inarticulately, is early judicial intervention in a case is very important. And you have that first conference to talk about what the case is about. That can sort of, in some extent, minimize the negative impact of a mandatory disclosure rule. Because then the judge can take control of it and say, here's what you have to, but here are the things we're going to negotiate that you're going to do in stages, and here are the deadlines we're going to put in place.
38 years ago when I took office, that was what I implemented. Upfront, early calls, what's this case about? When do you want to try this case? All those things that Michael talked about. But I do want to say something concerning Aviva. When people from Sacklers can meet in a motel room with the head of the FDA and get a warning label on oxycodone that it's not addictive except in 2 to 3% of the people. And then that head of FDA, when he leaves FDA, goes to work for salary for Purdue Pharma. I'm a little familiar with that case in Virginia because one of the attorneys in that case is my cousin. So I know a little bit. So I would ask, I don't know if I should ask billions or whatever, how much money is being spent on advertising by pharma on prescription drugs? I can't go and buy them, but look at the news. Almost all the advertisers for every major network are pharmaceutical. I mean, we all know about all these drugs. Why are we paying for the advertising of drugs so that we can all go to our doctors and ask our doctor about this drug or that drug that we can't even buy without the doctor telling us it's right for us? How much is that increase? So the problem that you talked about, we don't own FDA. Well, I'm not sure Sacklers didn't. Sorry.
So, no, not at all. So 2 different pieces. I can't speak on behalf of the Sacklers, obviously. I can tell you what my experience has been. As to your question about direct-to-consumer advertising, it's something that's permitted in the United States. It's something that's every sentence, the font, the music, the images that are used in those advertisements are approved by FDA. What isn't approved by FDA are the media campaigns by lawyers who are advertising about the same products, which is interesting. Look, I think that direct-to-consumer advertising it's a hot issue, right? Why do we do it? For the very reason that you articulated. You will go to a doctor and ask about it, and the doctor will then make a decision based on a balance of risk and benefit for you. Sometimes in communities where doctors are not as educated, that serves a really good purpose for patients. Sometimes, it's irrelevant, and doctors are up to speed on the very latest in a therapeutic area. But it is permitted in the U.S. It's highly regulated. And I will tell you that the amount of money spent on direct-to-consumer advertising as compared to research and development is minuscule.
Mr. Warshauer, I appreciate but also take issue with what I interpreted as
Step
your...
a little closer to the mic.
Is that better?
Yeah.
I take issue with what I interpreted as your referral to the judges as being sort of spineless and enforcing any kind of decorum. 10 years ago, the state of Wyoming approved a professionalism civility rule that we then in Colorado tried to adopt. And I walked away with my tail between my legs from the response of the trial bars. I thought things were pretty uncontroversial, like telling the truth or conferral being better than 5 to 5 on a Friday afternoon, and that's good enough. What is it that it's going to take to get both bars to support having a code of conduct that the judges can enforce? Because we want it. But we're getting resistance from the bar.
I think the code of conduct is there. I think it just needs to be enforced. It doesn't take much. People are embarrassed with a $500 fine. It's enough to get their attention. Nobody wants to pay it. Nobody wants to see it. But I think the code of ethics is there. We're supposed to be candid with the courts.
It's absolutely there, but we try to codify it to make it easier. One of the issues we were facing is then when you face retention and things like that, the kind of criticisms, because it wasn't as specific as it was to codify it in a way. And as I said, in Wyoming, they had a great deal of success when they did adopt the rule because they were able to point to something specific with specific language that was effective to be able to do exactly what you're asking the judges to do. We tried to do the same thing, and again, it was the trial bar that said, no, we don't want to do that.
Can't speak for all of them. Keep in mind, it's the same trial bar that wants to have mandatory insurance for doctors and cars and trucks, but won't do it against themselves.
And again, I'm not trying to be critical. I'm trying to figure out, I'm more looking for your guidance as to what can we do different to get the support of the bar to say, yes, those are the rules we want to live by.
A significant, I don't have an answer. I can tell you this. A significant amount of my work comes from other lawyers. I often parachute in. The plaintiff's lawyers are as bad at everything I said, they're as bad at it as the defense lawyers. Objective form, stupid objections on written, failing to produce stuff they ought to do. Hey, we don't make the facts. Just put them out there and let it go. And at the end of the day, I don't think you're going to get a lot of help from the bar. I think that the courts have to be the adults in the room.
Thank you. So I know we can get at least one more and maybe two, so.
Well, Mr. Warshauer, I'm gonna piggyback because I'm just from a little small county in Texas, right in the middle of Texas. However, it is one of the fastest growing counties. And I'm the only judge in that county, so I don't have a county court at law, and I just have one district court, and it's me. And so when I get a case, I take that case, and I work that case. So you put in there that the judges will just let cases go on and on and on. And I can guarantee you, at least for one little bitty county in the great state of Texas, no. Because I know once you file a case in my court, I know your case. I know the lawyers, and then I make you have a scheduling order at the very beginning. Within 30 days of your answer, you're coming to see me. Sometimes I get to 60 because it's busy. But normally I'll get a scheduling order. Now, for your conversation and your comment of an early dispositive motion, I think that's a lovely idea. I love it, and I will read it, and I will dispose of a case like that. I'm probably one of the fewer. I've got some other Texas court judges, but it's hard to get a summary judgment. But I'm going to grant your summary judgment if it indeed is warranted. Now, the problem that lawyers, when you say, well, it has to be pushed by the lawyers, it has to be pushed by the lawyers. So the problem with the judges, you say it has to be pushed by the judges, it has to be pushed. But every single time I try to implement an early dispositive, because I can see it. I want a briefing, I want to see that. Well, but judge, we're too early for that. We can't do that yet because we've got too much. Well, we haven't done all the discovery, and this is with all due respect, plaintiffs' bar and defense bars, and so they usually come in holding hands. About the only time I can ever get them to hold hands on anything is that, oh, we're not ready for the dispositive motions. So, as a practitioner in front of a much more distinguished judges than myself, because you've never practiced in my court, I would love to welcome you into Kendall County, Texas. But when I do, and you come into me and you're going to tell me I'm not ready for that just yet, or somebody is probably going to tell me, probably wouldn't have the luxury of seeing you, I'd probably see somebody who worked for you, that then would come in and tell me that they're not ready. How do you suggest that judges push the cases and say, I want that earlier dispositive. So what I'll end up doing is saying, well, I want it by this date. You can file it whenever, but I want it by this date. But how do you suggest we push lawyers to that place where we can get it out when we can see that without having one or the other or both most of the time push back on that? I feel, Mr. Warshauer and Mr. Stengel, that it is the bar, not the bench, that's elongating the case. So I want to know your suggestions, other than sanctioning for discovery abuses, which I do. But I want to know how you suggest that we push a case faster, because that seems to me your number one complaint about the judiciary. So what do you suggest we do different than we're doing? Or maybe some people aren't doing it. So how do you think we should get the plaintiffs bar on board to an early dispositive motion without having to do all the discovery?
I think both sides are often scared because they don't know what they don't know. And so they want to go a while to figure it out. But I think a candid discussion early on where you say, hey, look, you've got a statutory employee defense here. That's a question of law. Let's just get rid of that. It's a question of law. You don't need facts. The ones that I'm concerned about are often questions of law. There's 2 or 3 facts. You have the discussion. What are the facts that are going to support this question of law? Is there a duty here? What is your best case scenario? What facts do you must have to show the duty exists? I think that can be a discussion that had, but before I leave this, I want to say one thing. Judges the metric that should judge a judge is not how many matters you close, but how many trials you hold. That's what I want to leave as your overall rule. The goal is not close matters. The goal is, whenever possible, to give that amazing gift of the 7th Amendment to the parties, the right to trial by jury. But do so in the idea that if the parties and the court can identify these issues early on, that they really ought to work to do it. It's not every case. Most cases, there isn't a dispositive issue. Most cases I bring, 99% of them, there's a genuine issue of fact. The legal questions are pretty rare that are case killers in my practice. But where they're there, I'd like them done and be done with it. And I don't, it seems like everybody thinks I'm criticizing judges. I think judges are great. I think they're great. My father was a judge. I love judges.
My response was, well, Judge, this isn't a legal issue, and we need more time to ferret out the facts.
I think
And that's the answer that you're going to get as a judge.
then if the defendant says it's not a legal issue, say you're bound by that, we're done, we're going to trial.
You've been waiting patiently, so if you could, you said it was short, so.
I'm also from
Sneak her in.
Texas, and I'll be short. Ms. Wein, I saw my doctor a couple of months ago, and I noted you used the word, it's permitted. Permitted. He shared with me this. Why does Canada have so much less cost for prescriptions? And the answer was, they are not allowed to advertise on television or any other way. And the second thing he said was, it has brought patients into my office not because they're sick, simply to say, I want Wegovy. What's your response to that cost?
So my response to the first, I didn't realize we were doing congressional testimony, but we can totally do that. My response to the first portion of your question is that's false. That's simply not true. That's not the difference between pricing. Advertising is not it. And my response to the second is, if you see an advertisement, you come to a doctor and you say, I'd like that product. The doctor is the one who prescribes. The doctor has to decide whether that product is the right one for you. The doctor looks at all of the benefit and risk information and decides whether you have or are in a disease state that requires treatment by that product.
And that patient has incurred an expense which drives up our healthcare costs, even if they don't get the prescription.
To visit their doctor, you mean?
Yes, ma'am.
Okay.
Well, if everyone wants to give the panel a hand.